Anything going on?
I did the assessment. And, I was supposed to do it the 21st, but they called me the 20th. They called me earlier that day and had me scheduled for the 25th. I did the 25th and I did it. So I told them I'll do the treatment. And then the 26th, my grandpa passed away right in front of me. And it's just been a hard week for me, but I told the counselors or whatever that I'd do treatment.
That looks like, we do have the eval, just a question of starting, I guess. Well, what's your plan now? When do you think that's going to happen?
I honestly don't know. I actually just found out the other day that I no longer have health insurance, so I honestly don't even know how I'm going to do that.
Well,
I don't know if they told me how much it cost. Did it just pay for it out of pocket? I don't know. But,
have you gone in and talked to them about that? Usually these
no,
agencies are they know that what situations are and
well,
those who have insurance and those don't, and they're usually pretty good about working something out.
Yeah, at that particular time, I had health insurance, and then they told me I'd have to switch health insurance and to the other state medical health insurance or whatever. Because the one I had didn't take, so I had to switch. And then we got a letter in the mail like 2 or 3 days ago saying I don't have health insurance no more.
So Joey, any suggestion there? Usually what a person does is, if all of a sudden they realize they're in a financial difficulty, is go to the agency and say, hey, look, here's the situation. What are we talking about money-wise? Can we work something out? Payments, and you haven't done that?
No, I've been not sleeping, not eating, because my grandpa passed away last week, and I've just been helping my dad.
I'm sorry to hear that.
Well, let's reset for 30 days. Or add 30 days.
Mr. Gus, that's kind of traditional with the courts, either comply or impose a sanction, and the sanction is invariably jail time, which what that doesn't do you any good, that doesn't do me any good, that doesn't do anything. It's the point of it is to hey, what do we need to do to make sure that you don't keep repeating what happened on March 9th of 2020 and June 14th of 2020. That's the entire point, and we are our own worst doctor. These agencies, yeah, they do have some self-interest, but they're also experienced and educated in doing this. That's exactly what we're going to do. We're going to set it out 30 days. I'll sign an order to that effect. March 3rd, 8:15. And as I've heard many judges say to many clients that I sat beside, bring proof or bring a toothbrush, one or the other, one or the other. Is that, I don't want to do that. That's the absolute last resort. But hey, I'm leaving it up to you, Mr. Goss. I'm just leaving it up to you. That's good luck to you. I've signed an order to that effect, resetting the matter. You can get a copy of that by going out into the window to your left as you exit the courtroom, and that'll remind you of your court date. Good luck to you and take care. And you as well. Other than that, how is life going? Are you?
Oh, I'm doing really good. I'm working kind of sort of like I work under the table, but it's legal. I fill out.
Okay, don't want to hear about that, but I'm glad to hear you're working.
No,
that's great.
It's legal. It's you got to fill out a certain form and you figure your own taxes out of your own pocket. It's like contracting work.
what I've seen, what I've heard, what I've read about, the last thing that people need to worry about these days is finding work. I see for hire signs everywhere I go.
I work for
Good luck, Mr. Cox. Mr. Anderson. Let's call the matter of Yelm versus Troy Anderson. Mr. Anderson, are you there? You're muted. You're gonna have to unmute yourself. We can then call.
I am here.
I can hear you. Good morning. It looks like you're at the end of an SOC. Your attorney's Dan Crow. Are you expecting to hear from him?
No, I wasn't told to. No, I was just told to appear here at court.
Okay, then, well, it looks like you're coming up at the end of an SOC and there's still $25 owing on that. Is that something you can take care of right away?
Yeah, I can take care of it here in just a couple minutes. I just live down the street.
Hey, Mr. Dilly just nodded his head. It's okay with the prosecutor. If it's okay with the prosecutor, it's okay with me.
Yeah, we'll pay it online here in just a minute.
Hey, take care of that and you'll be good to go.
Okay, thank you.
Break the hearing as soon as we confirm that that's been done.
You said we'll break the hearing as soon as it's been done?
Hey, great, will do.
Okay.
Which one? The jail. Oh, the jail. Oh, we don't have anybody else. Oh, sigh. But we do have a jail one.
All right.
We'll come back to warrants on that. Mr. Sheehan, good morning.
Morning.
I'm assuming that Mr. Haverco is there in the neighborhood somewhere.
I'm not sure. I haven't talked to him this morning, Your Honor. He's not with me personally. He might be having to call over the phone like last time. I'm not exactly sure.
The jailer just brought you and plopped you down there. You haven't seen Mr. Haverco yet?
Yeah, no, I have not seen him in person. No, sir. Hey, do you know my judge or my attorney to call? My attorney is supposed to call.
Shoot, Brent, any idea? Can you maybe text?
I don't think,
Dan and.
yeah.
I've even tried I tried calling him this morning and he didn't answer me. I tried calling over the jail, like the personal jail phone in the unit, but I didn't get an answer, so I'm not sure what's going on.
Mr. GN, we don't want to go into anything until we hear from him, but thank you.
Okay.
Morning. Are you here for 8:15 court, 9 o'clock court, 9 o'clock? Public defender will be here and be able to talk to you before we call your case.
Well, given that I think Mr. Haverco has spoken to Mr. Sheehan. I've got a text from Mr. Crow as a matter on the calendar that he'd like to talk to me about, so if I may be excused.
So we'll see what the, I guess we'll pause
Judge Meyer, are we waiting for his attorney?
Uh, Yes, sir, we are. Right now, we're trying to figure out where he is. Evidently, everybody's communicated with one another, but for some reason, he hasn't shown up at the jail yet, and I'm not sure why.
Huh? Do you want to go to the next case while we're waiting?
Dan, no, the prosecutor's out of the room.
Okay.
We're trying to get a hold of him. So yeah, otherwise, yes. How is Miss Schwer doing this morning?
Well, she's doing a little bit better than what she normally is, but
That's good. Yeah.
we're dealing with a few MI issues.
That was a tough one.
Yes.
Hey, but thanks much. No, please, if you just stand by
Yeah, no problem.
a little bit, and we'll just see what shakes out. This is starting to be a weird day, but thanks.
Yeah, no problem. Judge, can you hear me?
Hey, good morning, Mr. Haverko. Good morning.
Good morning. If you could give me just a minute.
It looks like Mr. Dilly is out of the courtroom, but he'll be back in.
Okay. Yeah, just give me a minute, Judge, and I'll be right here in just a minute.
Okay, we'll stand by.
Judge, do we have a prosecutor?
Don't even have them in view yet. I'll send out the search party.
Okay, thanks, Judge.
You have two, Mr. Sheehan, of course. I'm looking at his statement of defendant, and then Amy Schwer.
Yeah, and I'm not sure about Ms. Schwer, if she's gonna appear this morning or not. She's in a holding cell right now, and
I talked to the jail, came on to ask us what was going on, and I inquired of her, and jail said she's doing a lot better today.
okay, good, good. So I think we'll probably be able to dispose of that case today as well, Judge.
Good.
Have you talked to Ms. Schwer today yourself?
I personally have not talked to her yet.
Okay.
As soon as we go back on record, we'll take back on record, call the one of the in custody matters, Yelm versus Devin Sheehan. Present electronically is Mr. Haverco. Also present is Devin Sheehan. I'll ask Mr. Haverco how the matter is going.
Oh, well, thank you, Judge. So I've had an opportunity to discuss all of the numbers of cases and charges with Mr. Sheehan. There's 4 different cause numbers, and there's a total of 10 charges spread out amongst the four cause numbers. And so what we're proposing to do, as enumerated on the statement of defendant on plea of guilty, which I've reviewed with Mr. Sheehan, we're proposing to plead guilty to 4 of the thefts. I believe there is just 4 thefts, and then 1 criminal trespass, or excuse me, 1 possession of stolen property. And then there's 1 other criminal trespass and several other possessions of stolen property. So essentially pleading guilty to 4 thefts, 1 of the PSPs, and then dismiss everything else. So you have 10 charges on the table. He's pleading to 5, dismissing 5. We're entering on each and every count, we're entering an Alfred plea. It partly has to do with recollection issues. And but I've reviewed with him what an Alfred plea is. He agrees that based on his review of the evidence, he agrees that if all the matters were heard, or if the matters that he's pleading guilty to were heard by a fact finder, whether that be a jury trial or a judge sitting without a jury, he believes it's highly likely that a fact finder hearing that evidence would enter a finding of guilt. And based on that, he doesn't wish to contest, if you will, the validity of the evidence, and wants to also enter a plea in order to take advantage of the city's plea offer. And so with that in mind, he'd like to proceed.
Mr. Sheehan, is your full name Devin Tyler Sheehan?
Yes, Your Honor.
You disagree with anything Mr. Aberco just said?
Yes, Your Honor.
Now, if I accept
Oh,
the
wait.
rights contained in paragraph.
Oh, no, sorry. I thought you said, my bad, sorry. I said agree, not disagree.
Could you repeat that?
Oh, he was just trying, he was saying, Judge, he meant, when you said, do you disagree? He said, yes, he meant to say no. He just got a little mixed up on the word.
Understood that way for some reason. You give them the rights contained in paragraph 5, no trial, no appeal, there'll simply be a sentencing, which could be up to 1 day less than a year on each of 5 counts of gross misdemeanors. You realize that?
Yes, Your Honor.
Have you gone over the plea form with your attorney?
Yes, Your Honor.
Did he answer every question that you might have had regarding the effect of entering pleas of guilty?
Yes, Your Honor.
With that in mind, as to 1 count of theft alleged to have occurred in Yelm on December 6, 2021, how do you plead guilty or not guilty?
Guilty.
And with regard to 3 counts of theft and 1 count of possession of stolen property alleged to have occurred within the city of Yelm on December 6, 2021, how do you plead guilty or not guilty?
Guilty.
This is in the nature of an Alfred plea. I have reviewed the probable cause statements and do find there is a factual basis for the pleas. And you are entering the plea to take advantage of the plea bargain. Is that right?
Yes, Your Honor.
Mr. Doyle, anything to add to?
Nothing to add, Your Honor.
Mr. Haverko, anything further?
Nothing to add, Your Honor.
Mr. Sheehan, how about you? Is there anything you'd like me to think I should know? You don't have to say anything, but if you, now's the time, and that's your right.
No, Your Honor.
I think the recommendation is you're on jail less than a day on each charge, credit for time served, the balance suspended on the condition of law-abiding behavior, no fine. I'm inclined to follow that. Mr. Sheehan, you've been in by my count 28 days. I'll impose 364, sentence, give you credit for 28 days served. That leaves a sentence of 336 days suspended on each charge. 336 times 5 is a larger number than I care to compute at this time. Now, unless there's some other hold on you that you are going to be released today, it would probably be an understatement to say you've been something of a one-man crime wave. And in that connection, the other 5 gross misdemeanors are being dismissed. However, if you reoffend, and I understand you were arrested while recommitting one of the offenses, but if you're rearrested on this, you can pretty much count on having quite a bit of jail time imposed. Understood?
Understood, Your Honor.
All I can do is wish you the best of luck and hope that you stay out of trouble. We'll be sending you a copy of the judgment and sentence. Your attorney will likewise have a copy. If there's any question at all, give them a call, okay?
Okay, thank you, Your Honor.
Thank you, Your Honor.
I need the statement as we speak. Julie, I don't know if you're able to sign off on the JNS form giving me a equipment you have that if you can't, we'll just waive signature.
I signed that judgment.
As of now, so have I. We're waiting for, Mr. Haverhill is talking to one other in custody. If we have an attorney matter we could take now,
Yeah, I believe
if
Mr.
it's
English
convenient to do it.
I believe Mr. English is ready to, we have a couple things to put on the record.
Okay.
Call Dinah Sanchez.
Sanchez, good morning. Go ahead and have a seat. Matter set for a pre-trial. I'll defer to your attorney for the status of it.
Thank you, Your Honor. Your Honor, I've been in contact with Mr. Dilly and we've negotiated this case, talked about it, and we have an offer on the table. My client just needs a little bit more time to think about it and ask me any questions that may come up and so on and so forth. We're just asking for a brief 3-week continuance, and I anticipate that resolution is right around the corner.
Reset the matter about how far out?
3 weeks.
We can go 2 or 4.
The
About a
17th
month.
17th is okay. 17th, Your Honor.
17.
Actually,
Maybe not.
I have a DOL hearing at that time.
Then we'll have to go out.
If we can go into March.
Sure. March 3rd at 9.
That'll work for us.
Mr. Dilly, any objection, I assume?
No objection, Your Honor.
I'm signing in order, resetting it to March 9th at 9 a.m. Sanchez, any conditions of release earlier set remain in effect, and stay in touch with your attorney, and we'll see you back here next month. Take care of yourself in the meantime, and I am electronically signing the reset now. I don't think we need the party signature on that.
Thank you, Your Honor. And then does
So
she-
you
does
can
she
get a
sign?
copy of that by going to the window just outside the courtroom and to the left.
Very good. Thank you.
Mr. Sanchez, good luck. You take care of yourself, and we'll see you back here next month. Any questions?
No, no, sir.
Concludes the hearing. Good luck.
You know, Then my other matter is Hunter Smitha, when the court is ready.
Certainly. Hunter Smith, Mr. Smith, come on up and have a seat next to your attorney, and we'll address your matter now. Good morning. I'll turn to your attorney for the status of the matter, which is set for a pretrial at this time.
Thank you, Your Honor. Your Honor, the parties are prepared to resolve the matter by entering a stipulated order of continuance. I went ahead and filled out the form yesterday, signed it, and I believe City has had a chance to sign it too. I explained it to my client, however, he still needs to sign off on it. Would I be able to pull it up on how would the court like to go about it?
Well, we can just say served on defendant, we get a copy of it, that'll save us the trouble of having Mr. Smith explain it. I'll go over it with him a little bit to make sure for the record that he understands it and proceeds.
Fantastic, thank you.
If that's acceptable to the parties, I assume.
Yeah,
it is.
fine for the city, Your Honor.
That'll work great.
Mr. Smith, I'm looking at an SOC, stipulated order of continuance. It's called a lot of different things, but what it is, in essence, is a contract that your attorneys negotiated with the city. It puts you in a pretty good position. You're able to walk away from this thing with no damage done, no convictions on your record. But the rest of it is up to you. The rest of it is principally law-abiding behavior. It looks like the box is checked, restitution to be determined. That may or may not become an issue. If it becomes an issue, if there is a restitution request, you're entitled to a hearing, and you're allowed to dispute the amount of any restitution requested. That is the most principal obligation. Now, if you violate the agreement, appear timely, no criminal law violations. If you violate the agreement, you've given up your right to trial. We'll simply have a hearing based on the police report, and you know what would happen more times than not with that. You realize that?
Yes, sir.
Once again, your attorneys put you in a position, no damage, but the rest of it is up to one person, and I'm looking at it right now. We all make mistakes in life, and hopefully we all learn from them, and I hope that's been the case here. If there's anything that's necessary to keep you from ever having to listen to a judge bark at you again, discuss that with your attorney and take his advice, okay?
Yes, sir.
Questions? Alexia? Sign off on the order of continuance, and you can get a copy of that by going to the front desk, just outside the courtroom and to the left.
Yes, sir.
Good luck to you.
And Your Honor, there's actually one remaining item that I think we need to take care of as well. The city and I agreed on this position for the other pending case. I can get the cause number right now for the court.
I think that's the XZ0823307.
That's correct.
That's the aiming to discharging a firearm. Yes.
And Your Honor, in exchange for the stipulated order of continuance that was worked out for the latest cause number, we're agreeing that Mr. Smith will be entering a change of plea for the XZ, along with an agreed sentence and recommendation.
And that agreement, Your Honor, is no jail time, further jail time imposed or suspended, and no additional fine imposed or suspended. Close the case.
That is, I don't have a statement of defendant on plea of guilty.
I think it's an SOC, Your Honor.
What now?
It's an SOC.
Oh. Okay, got it. And once again, what are we doing here?
We're just simply changing there was a violation. So that tripped up the SOC. So we're simply changing the entering a plea of guilty and closing the case.
We're stipulating the violation.
There is going to be a plea of guilty?
They're stipulating the violation.
Okay. Got it. Any other action is necessary?
Nope. No additional jail time imposed or suspended, and no fine imposed or suspended.
Hey, that's it. Mr. Smith, the nature of the charge, that always makes me cringe a little bit, especially when I look at like the news this morning, firearm deaths and shooting up 50–60% here and there. And a lot of that is blamed on the pandemic and a lot of other issues as well. But it's nothing good happens when people start shooting guns at one another. All you have to do is read any morning news, and it principally involves the shootings from the night before. So good luck to you. You take care of yourself, and you, your attorney, I thanks for minimizing the damages here. Good luck to you.
Thank you, sir. Thank you, Judge.
Once again, signing the it's necessary, and that takes care of the case. Smithy, you take care.
Thank you, sir.
Mr. Aberco, back to you.
Good morning, Your Honor. I had an opportunity to meet with Ms. Schwer. And I have to say, I tried to talk to her a couple of days ago. And apparently she was in a state, as I was advised by the staff at the jail, that she was in a mental state that would be described as somewhat agitated. And she did not want to speak with me. And so I attempted to speak with her this morning. I saw her face to face. She was in a holding cell in the lobby of the jail. And I guess if I had to describe her temperament, mood, she seemed quite agitated, and not really. She was partially oriented in time and place, but I was unable to really talk with her about what's going on or what to do. I suggested to her that, hey, we could just do the arraignment. She didn't want to do that. She demanded that everything just be dismissed, and then just sort of became more hostile. I mean, just there was a quickly rising level of hostility. And I tried to explain to her that, I have a contract with the city. I'm in the role of a public defender. I'm not with the police. I'm not with law enforcement. She kept asking me for my badge. And I said, well, defense attorneys, we don't carry badges. It's not a type of a job with a badge. And so she just, I was not able to make any progress. So I don't know whether to set the matter over a couple of weeks, and maybe Your Honor might, I don't know if Your Honor might consider ordering, consider release upon maybe evaluation by a, mental health professional or something of that nature. But
That was my inclination to PER with subject to a DCR
right.
evaluation, and give her a tentative court date. Given the nature of the offense, I'm not sure Mr. Dilly's had a chance to review the police reports, and that it is a kind of rather, people usually don't shoplift at Goodwill. But,
Right, exactly. Yeah, we're talking, right.
I'll hear from Mr. Dilly, but that's my inclination is to, because that was the problem when I called the jail right after she was arrested. She wouldn't come to the phone and talk to me, even though the jail said that he's going to release you.
Right.
But yeah, Mr. Dilly, that's any thoughts? I'm inclined to, that is the other concern I have. If I just simply PR with the court date is,
We'll never.
I'm not sure she has any place to go. And
No, I mean, yeah, I mean, I think probably the best approach would be, because I do think if you PR her, I mean, on the one hand, in my very narrow role as a defense attorney, I suppose I should just argue for her unconditional release. But I also, like Your Honor says, I acknowledge that it's probably highly unlikely she would return to court.
on the phone in the jail, we'll never see her again.
Right.
Upon an eventual warrant. So that's.
But she appears to need maybe some kind of help, or possibly there may be a medication issue or something. I'm not sure exactly what the nature of the issue is, but there was kind of a again, as a non-medical professional, I guess I would describe it as kind of a coherence issue, an inability to really communicate and focus. So yeah, I'm not sure what the problem is, Judge.
Order evaluation.
That's what I'm gonna do, is,
Okay.
off record, I'm gonna prepare a PR order subject to a DCR
Right,
event.
okay,
And I'm quite sure that's, based on what I've heard. And,
Yep.
That she will be committed for treatment.
Right.
I'm quite confident of that.
right.
And that concludes the.
Yeah, that concludes, yeah, thank you, Judge.
In custodies, Mr. Havigal, we'll see you here in a little.
Okay, thanks, sir.
Take care. We off record? Okay, good. Do we have anybody else on the 9 o'clock calendar? And apparently we have Miss Wiggler on the.
Okay, I think we have a number of matters to put on the record.
Good morning, Ms. Wiggler. We're going to take your matters now. I'll defer to you for the order of preference.
And thank you, Your Honor. I actually have 3 matters. I'm covering for one for Miss Anderson. The one I'm covering is the Arlene Mashkowski matter. I have to have a breakout room to go through the SOC form with her, but I'm ready on my 2, the Peyton Lewis and the Priscilla Cannell matters.
Unfortunately, we don't have breakout capability here.
Okay. So maybe what I need to do is handle the Cannell and the Lewis matter and then call Miss Mashkowski and then come back onto the hearing.
You can certainly do that. You want to take?
Okay, great.
Ms. Cannell first? Or
Yes, please.
Well, the matter of Yelm versus Priscilla, Valenzuela Cannell. Except for a pretrial this morning. Ms. Cannell,
And thank you, Your Honor. Lauren Wegener on behalf of Ms. Cannell. I have uploaded a stipulated order of continuance form into O Court. I've also had an opportunity to go through this form with my client. I believe that she understands the rights that she has and those that she gives up by entering this stipulated order of continuance. I've explained it to her to essentially be a contract between she and the city where she needs to complete certain obligations. And if she does, then she will be benefiting from the resolution that's proposed. Thank you.
Ms. Cannell, you appear to be muted. If you could unmute yourself, we'll proceed with your matter.
Okay,
Good morning to you.
good morning.
Do you disagree with anything at all your attorney just said?
No,
Your attorney has negotiated with the city a contract under the terms of which if you comply with some conditions, this charge will be in time dismissed. The conditions principally are law-abiding behavior, stay out of trouble, no criminal driving offenses, and if you do that and pay a probation fee of $500, the charge is going to be amended down to a 1 count of negligent driving in the first degree. The maximum penalty for that would be 90 days in jail and or a $1,000 fine. And the fine on that would be, if it goes to that, at $500.
That's correct, Your Honor. I think that's what's in the order.
Ms. Cannell, your attorney has negotiated for you a very favorable resolution under the terms of which you can walk away from this with a much, much less serious charge if you comply with the conditions. Now, in return for the agreement, you've given up the rights to go to trial, have witnesses. If it's proven that you have violated the agreement, we'll have a hearing simply based on the police reports, and you know what that would result in. Something of a disaster in terms of possible jail time and your driver's license. Okay?
yes, sir.
Your attorneys put you in the position, but it's up to you to abide by the conditions and get the eventual benefit of the bargain. This is a 3-year, 36-month agreement, so it's going to be a while. And the other condition, of course, is if your contact information changes, your address changes, you need to let us know that, okay?
Okay.
Scannell, I'm going to wish you the best of luck. We'll be sending you a copy of the agreement and a time payment agreement. If there's any question at all, get in touch with your attorney, okay?
Thank you.
All I can do is wish you the best of luck and remind you that driving a car is probably the most dangerous thing you're ever going to do, and it's going to be highly dangerous if you're under the influence or allegedly under the influence of any substance, okay?
Yes, sir.
Good luck to you.
Your Honor, I just wanted the court and Ms. Cannell to know that my office did fax a copy of her evaluation, alcohol drug information school, and the victims impact panel to the court yesterday. And so those affirmative conditions have likely been addressed at this time.
Perfect. Yeah, if there's, Ms. Cannell, that's part of the drill. If there's a problem here that needs to be addressed, let's find out what it is and address it so you don't have to face a situation like this ever again, okay?
Okay.
Good luck to you.
Thank you.
Thank you, ma'am. And with the disposition bond posted will be exonerated. I'm signing the document as we speak and close. Mr. Lewis, good morning. How are you?
Good morning. Doing good. Yourself?
You're doing well. Your attorney's present as well. I'm going to turn to her for the status of the case.
Thank you. This is also a resolution. I've had an opportunity to also discuss with my client the offer that's on the table, which is a stipulated order of continuance. Mr. Lewis, I hope you were listening to Ms. Cannell's case because it's very, very similar to yours when it comes to what you're obligated to do and that you reap the benefits of the agreement as long as you abide by all the terms and conditions, okay?
Okay.
Thank you.
Mr. Lewis, I'm for the record, your name is Peyton John Lewis.
Yes, sir.
I'm looking at the stipulated order. Have you gone over there with your attorney, and if you had any questions at all about what you were obligating yourself to do, were those questions answered?
Yes, they were. I just have one question is about when my license, because I know there is going to be a 30-day suspension when it starts. I was wondering when that starts because I'm at work right now and I still need to drive myself home after work.
When you are convicted of that offense, that conviction notice will go to DOL and DOL will then send you notification of that suspension. So you always need to make sure that your address is current with DOL because at the tail end of the stipulated order of continuance is when you should be expecting that documentation.
Okay.
Yeah, the Department of your attorney put it exactly right. I don't need to go into that further.
Alrighty.
Lewis, your lawyer has negotiated with the city a contract under the terms of which, if you comply with the conditions, you get a significant reduction in charge to that of reckless driving. That does have a DOL consequence, but it's much less serious than a DUI conviction, much less. You need to stay out of trouble over the next, I'm looking for the period of time here. I have to read this on a screen. This is for 2 years. If during the 2 years you comply with the conditions, you get the reduction. Conditions are pretty numerous. Principal among them to me is no criminal law violations, especially involving substance and driving. Any officer asks you to take a breathalyzer, you do so. Don't refuse a breathalyzer. Update your address with the court and Department of Licensing if you need to do to, and get a drug and alcohol assessment and start complying with any recommendations within the next 30 days. That can be
Okay.
to do in the COVID era that we're in. So if there's a problem with that, just stay out of it, okay?
Okay.
And Your Honor, I apologize. I think that this is supposed to be a 12-month stipulated order of continuance. Mr. Dilly can confirm that. I put February 3rd, 2023 as the commencement date, and then I see that I put 24-month SOC, which I think was supposed to be a 12-month. Can Mr. Dilly confirm?
Yeah, that was the agreement.
That was the,
Okay,
we'll amend that to 12 months.
thank you. I appreciate that. Sorry about that.
No problem, Mr. Brown. Mr. Lewis, the only difference is you'll hear from Department of Licensing about a little more than a year from now, and not any further period of time, okay?
Okay.
That amendment has been made to the form. And again, Mr. Lewis, it's important that you comply with the agreement. If I didn't say so, a violation of it will lead to a reading of the record, whatever evidence the prosecutor wishes to submit, and that would result in pretty serious impact on you in terms of possible jail time and your driver's license. Any
Okay.
questions?
No, sir.
Again, I wish you the best of luck, and of course, your attorneys put you in a great position, but it's up to you to follow through.
Okay, sir.
Sending you a copy of the SOC. Read it over carefully, and if you have any questions at all, contact your attorney. All right.
All righty.
Good luck to you. That concludes the hearing.
Thank you. Have a good day, sir.
Mr. Lewis.
And Your Honor, I'm going to log off and I'm going to call Ms. Mezkowski, and then we will log back on as soon as I'm done going through the stipulated order of continuance with her.
We'll talk to you back then, and today's been kind of well, a weird one, but we'll get back here as soon as we can.
Okay, thank you.
Thank you. Well, that was this has never done this before. It's just out of curiosity. It worked okay, but I ended up. Call the matter of Yelm versus Isabella Wilmot. Mr. Crowe, if you're available, we'll address that matter now. Mr. Crowe, good morning. We'll call the matter of Yelm versus Isabella Wilmot. It's set for a pretrial. Is your client available? Yes,
Yeah, Your Honor, I spoke with her this morning after speaking with Mr. Dilly, and all we're going to do in this case, we've reached a resolution to the case, but we need to work out the details and get the paperwork in place. So all we're going to do is ask for just the very briefest of set overs. My client had to get to work, and I hope it's okay with the court, but I let her know that since all we're doing is just knocking this thing out for a later hearing, that she doesn't need to be present for that.
No problem. No problem. Ms. Wilmot, you're muted. If you'd unmute yourself.
Oh, she is here.
Oh, there you are. There you are. Good morning, ma'am.
Good morning.
Your attorneys asked for a little time to make sure everything is exactly the way you want it to be. Mr. Grohl, about how far out do you want to set the matter?
I'm pulling up my calendar now. We really don't need a lot of time because Mr. Dilly and I really have kind of worked things out, but there's just a few details, and to put the paperwork together shouldn't take much time. We could set this out for the 17th or for actually the 3rd of March might be better. I'm looking at having to be in court on the 17th in the morning already, so I generally don't like to overbook myself.
Always a good idea. March 3rd, okay?
Yeah, that'll be fine.
We'll need an order to that effect, which keep forgetting to hit the refresh button. Ms. Wilmot, your matters are reset to March 3rd. We'll be sending you a copy of today's order, and your attorney is going to get a copy as well. You take care of yourself, stay in touch with your attorney, and we'll talk to you in March.
All right. Have a good day, sir.
And you as well, Ms. Wilmot. Mr. Crowe, any questions?
No questions from me. Thank you, Your Honor.
Take care.
Have a great day.
You as well.
Take care, Dan.
You too.
And Your Honor, Lauren Wegener, I did have an opportunity to go through that form with Arlene Mauschkowski, and she's trying to get back onto Zoom now.
We'll wait for, as soon as she shows up, we'll take the matter. Sometimes that takes a moment. Perfect. Ms. Michkowski, you're now present. You need to unmute yourself. If you would do that, we'll take your matter now.
Hello?
Good morning. We can now hear you. We'll address your matter now. Ms. Wegener is here on your behalf, and I'll turn to her for the status of the matter, which is set for a pretrial. Ms. Wegener?
Thank you. Thank you. Lauren Wegener, I'm standing in for attorney of record Chloe Anderson. This is a resolution with also a stipulated order of continuance, a 12-month stipulated order of continuance, where if Ms. Mashkowski is in full compliance, her case will be continued without finding and then amended to reckless driving. I did have an opportunity to go through the stipulated order of continuance terms and conditions. She understands the rights that she gives up by proceeding this way and would like to enter the stipulated order of continuance today. Thank you.
There's a couple of citations as well, a speeding, expired registration. Is there a dismissal of that as part of the bargain?
Yes, Your Honor.
Ms. Bukowski, having heard Ms. Wegener's statement, is there anything you disagree with there?
No, sir.
Your attorney has negotiated with the city an agreement on the terms of which this charge will be reduced 12 months down the road to a much less serious charge, but still a serious charge, if you comply with a number of conditions here. That's appear scheduled, no criminal law violations. That to me is the most important one, especially if that involves alcohol. You obtain a drug and alcohol evaluation within the next 30 days and comply with any treatment recommendations. But to me, most importantly, stay out of trouble, okay?
Yes.
Now, in turn for the agreement, you've given up your rights to go to trial, have witnesses appeal if things go wrong. If there's a violation of the agreement and the city proves that, well, what happens is you're subject to a significant amount of jail time and also a pretty adverse result when it comes to your driver's license. You don't want to go there. Now, these things happen. The important thing is if there's a problem, let's address it and make sure that nothing like this should ever happen again, okay?
Yes, sir.
And once again, your attorneys put you in a position where you can minimize the damage here, but the rest of that is up to you. I want you to fully comply with the agreement, okay?
Oh, yes, sir.
Ms. Bukowski, any questions?
I already did all the evaluations and compliance already. And so is that presented today or is that presented at the end of the year?
That's presented within the next 30 days, within a reasonable period of time. If that's done, the sooner you get it on file here, the sooner that obligation is behind you.
Okay. And then I will get notified once that's done.
Well,
And Your Honor, I'll let Ms. Mashkowski know that we filed the alcohol drug information school and the victims impact panel today, I'm sorry. We faxed that over to the court and we're waiting for the evaluation. And in speaking with her, she said that her treatment agency would be sending it over to our office today. So as soon as we receive that, we'll get it over to the court as well.
Hey, Ms. Bukowski, your attorney is helping you out with that. That's good. I'm glad to hear that somebody is being proactive with their obligations and they're concerned with making sure that you don't put yourself in the same position again. I really appreciate that. Best of luck. You take care of yourself and hopefully down the road, this will be just a distant bad memory, not often thought about. Good luck to you, okay?
Thank you.
You take care of yourself.
Yes.
Ms. Wegener, that concludes the hearing. Thank you for helping out with this case and you have a great day.
Thank you. You all too. Have a good one.
Bye.
Bye.
Take care. And the infractions, go ahead and dismiss. Well, the 8/15 calendar turned out to not be so. Mr. Anderson did show up and Madam Clerk tells me that the $25 has come through. I take it we can just simply strike the hearing and close the case. Mr. Anderson is otherwise in full compliance. Ms. Alvin Gaddy did not show. That's at the end of an SOC with 125 owing.
$5,000 cash or bond.
So ordered. Handled Mr. Goss, he was present. Jaslyn Johnson, once again, has not appeared. Are we simply holding? Okay. Jaslyn Johnson.
You know, $5,000 cash or bond each? Oh,
Yeah, that's.
yes, we need to, sorry.
She was
She's been in-
multiple jurisdiction problems.
Yes, I think
remember
she's on her
well.
way to federal prison.
She's what now?
On her way to federal prison.
That doesn't surprise me.
So let's go ahead and we can dismiss these.
City's motion. That's a total of 1, 2, 3 different cause numbers. Ending in 785, 342, and 343. City's motion dismissed in the interest of justice. We'll dismiss and close. Yes, as I recall.
Yeah, I believe her sentence is 36 months for, I don't know if it's forgery or.
She had, I remember the case well, it was she in conjunction with the companion, and they had multiple offenses in multiple jurisdictions, and wears a cowboy hat and did not appear. And with that, I think we're waiting for the public defender to show up. He's en route from the jail, and once he's here, he'll be able to assist you with your matter.
So did the two other matters, did those resolve themselves? Number 8 and number 9?
Yes. Cease.
And
Talanoa.
Thrasher. Patel. So $5,000 cash or bond for each of these.
For Cease Talanoa and Tila Pressure Critel. So ordered.
We took care of all the 9 o'clocks today.
Yeah.
Only one continuous, so that's pretty good.
Back on record, Mr. Stephen, defer to you for the,
Thank you, Your Honor.
For the
I
order.
have a matter ready that is number, sorry, I had it. It's on the 11 o'clock calendar, number 1, Stephen Bertrand.
Mr. Bertrand, good morning.
Hi.
Mr. Bertrand comes on for a pretrial, Your Honor. At this time, we've entered into a resolution in this matter that I went over with Mr. Bertrand. A stipulated order of continuance for 12 months. He'll pay $150 probation fee. Stay out of trouble for the next 12 months. In this case, will be dismissed. Thank you.
That's all correct, Your Honor.
Bertrand, I'm pulling up the agreement now. I'm now looking at it. Have you gone over this agreement with your attorney?
Yes,
Have you
Your
had any
Honor.
questions at all about what it meant? Which questions answered?
No, thanks. He's got it taken care of. Thank you.
Mr. Sneed has negotiated with the city a contract under the terms of which you can get a real favorable result here if you comply with the conditions you've agreed to. Now, if you violate the agreement and the city proves that, you've given up your right to go to trial, have witnesses appeal if you lose. We'll simply have a hearing based on the police reports, and you know what that would result in. Nothing good.
Correct.
The conditions are really pretty simple, and that is, stay in touch, a bigger contact information with your attorney and with us, and also no criminal law violations, and of course, appear for court if scheduled.
Yes, Your Honor.
If you do that over the course of the next year and pay a probation fee in the amount of $150 and $25 a month, the charge will be dismissed.
Thank you.
Your attorneys put you in a position where the matter can simply go away, but whether that happens or not is up to one person, and that, of course, is you. Any questions at all?
No, I'd like to say one thing though, sir.
Yes, go ahead.
I'd like to apologize to Safeway Corporation, the city of Yelm, and the police. And I'd like to thank my lawyers and this system here for sending me in a better direction.
Mr. Bertrand, we all make mistakes. That's just part of being a human being. That as long as we forgive ourselves and make amends to others and learn something from it, I try to go on and make new mistakes and not repeat old ones that I've made. I want to thank you for those kind words, and it sounds like this is an experience that you've learned from.
Yes.
I'm going to wish you the best of luck. Sign off on the agreement. You can get a copy of that by going to the window out of the courtroom to your immediate left. But I will wish you the best of luck, and thank you for appearing, and thank you for your patience.
You're welcome.
Take care of yourself.
I have a couple of matters, but they're not. Sure. Okay.
Mr. Abigail, if you have a
Yeah, I
matters to
do.
present, I'll-
Yeah, I do, Judge. Just takes my computer to warm up just a little bit, but we're going to be calling. Well,
Once you
first
get
we
ready.
could call, just on the record here on the 10 o'clock calendar, number 2, Julie Bissau. I believe the city has a motion.
Yeah, so he's moving to dismiss without prejudice, Your Honor.
Okay, so ordered.
Need to log into Courts here. Okay. And the next matter would be number 3 on the 10 o'clock, Emily Christensen.
Good morning, ma'am. Go ahead and have a seat next to your attorney. And is your name Emily Nadine Christensen?
Yeah.
I'll defer to your attorney for the status of the matter.
Sign right here. Parties are proposing the court accept a stipulated order of continuance. I'm having her sign that document now. And I've gone over with her what a stipulated order of continuance is. We're proposing the case be continued for 12 months on the condition that she have law-abiding behavior, no criminal law violations, and pay $250 in fees.
And at the end of 24 months, the charge will be dismissed.
What did we,
Was it 12 or 24?
24, right?
Oh, what could be 24?
I have 24 in the agreement. Yeah, but the box for dismissed, that hasn't been. I can check that if that's the party's agreement.
Yeah. And then it's just.
And we're fine, and we're fine. Yeah, I just made sure the defendant knows, typically we do agreements that are 12 months. This agreement is 24 months. I explained to her that she just has to remain law abiding and pay the court fee over a 24-month period. She's understands and agrees to that.
What this is a contract with the city. Your attorneys negotiated it. The length of the contract is, as we just stated, 24 months. If during that period of time you pay a probation fee in the amount of $250, $25 a month. Most importantly, stay out of trouble. No criminal law violations. If you do that at the end of 24 months, the charge will be dismissed. It will not go on your record as any sort of conviction. Now, if you violate the agreement and the city proves that, we'll have a hearing based on the police report alone, you haven't given up your rights for this agreement. And you know what that would result in. That would result in a conviction, which doesn't help anybody, and possibly subject you to jail time. We don't want to go there. I'm going to wish you the best of luck, and I would like to see you comply with the agreement. Any questions at all? I'm signing it as we speak. I have to do that electronically instead of Christensen. I've now signed the agreement. You can get a copy of that at the front window. I'm in the best of, wish you the best of luck. You take care of yourself, and thank you for your patience, and thank you for appearing.
Thank you.
Take care of yourself.
Mr. Josh?
Is this Mr. Stanley?
This is this is on the 11 o'clock, numbers 12 and 13, Joshua Williams. Go ahead and sign.
Mr. Williams, good morning.
So I've prepared and reviewed with Mr. Williams a statement of defense on plea of guilty. He's going to be entering a plea to number 13, the case number that ends in 127. As part of the agreement, the city will move to dismiss the other case ending in 755. Recommendation is suspended jail time, 364 days of jail, all suspended to not be imposed for 12 months, so long as he remains law-abiding, no criminal law violations, and pays a $250 probation fee.
That's all correct, Your Honor.
Thank you, Mr. Dilly. Is your full name Joshua Williams?
Yeah.
Mr. Williams, I'm looking at a statement of defendant on plea of guilty that tells me you're 37 years of age. The plea of guilty would be to one count of theft in the third degree, which is a gross misdemeanor. The maximum penalty would be 364 days in jail and or a $5,000 fine. You're also looking at pleading to guilty to an amended charge of criminal trespass, second degree, which is a simple misdemeanor. The maximum penalty on conviction would be 90 days in jail and or a $1,000 fine. Now, I'd be free to impose up to the maximum if I saw fit, regardless of what's recommended here. You realize that?
Yes.
But accept the pleas, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, and that would conclude the matter. With that in mind, as to one count of theft in the third degree and one count of criminal trespass, second degree, alleged to have occurred within the city of Yelm on December 9th, 2021. How do you plead guilty or not guilty?
Guilty.
Do you make that plea of your own free will?
Yes, sir.
Anybody make any threats or promises to you to make you plead guilty?
No.
Your statement of paragraph 11 does satisfy the factual elements. I will find the plea to be freely, knowingly, and voluntarily made. I've heard the recommendation. Is there anything you'd like to tell me or think I should know?
No, sir.
Mr. Williams, looks like you've already had, from I can tell from the charge of trespass, that there's already been an issue with the store. I'm going to follow the recommendation, and a condition of the sentence, of course, is law-abiding behavior, and that would include abiding by any and all trespass matters. 364 days in jail, 90 days on the criminal trespass, all suspended on the condition that you A, stay out of trouble, and B, pay a probation fee in the amount of $250. Any question at all?
No.
I wish you the best of luck. It's going to take me a moment to completely review and sign. Statement.
Sign here. It's a judgment sentence.
Impose 1 year jurisdiction. Mr. Williams, that concludes the matter. I'm going to wish you the best of luck. You can get a copy of your statement of defendant and a copy of the judgment and sentence at the window outside the courtroom to your left.
Okay.
Read it over carefully, and if you have any questions, give Mr. Havercoat a call, okay?
All right.
I'm going to wish you the best of luck, and try to remember you have some suspended jail time hanging over your head to ensure future compliance.
Yes.
Good luck to you.
Thank you.
Take care.
Yes, sir, ready? I can do it, that will be, go ahead. Do you need to talk to those folks? Yeah. Okay. fair enough. And I'm ready when the court is with a couple of matters.
You bet.
First is Mr. Stanley off the 10 o'clock. I've got a motion to reset that matter. Mr. Stanley he was in treatment, lost his job, lost his housing. We re-engaged in those things, and we just need to get some more things to the court. I need to get an update from him as well, so I'm just asking to set this out about 8 weeks.
Hearing no objection. No, we'll reset it to April. Yes.
Madam Clerk, do we have a 290 number on there? 253-290.
290 and 571. Note that on appearance for speedy trial purposes, of course. Be set to March 31st.
Next. Are we ready for another matter?
We'll quickly sign this one. No.
Next matter, Your Honor, will be Jesse Palmisano, number 7 off the 11 o'clock. There is a motion by the city in the courts.
It's moving to dismiss.
That's correct, Your Honor, and that will be with prejudice.
Got it. It's signing. Does have a little age on it.
I spoke with Mr. Fleming. I'm not sure if he's trying to get on the Zoom or not, but tried.
Is he there?
Yes.
Andrew Fleming. Maybe it's a brother.
Yeah, well, he may be at his parents'. Could we ask?
Go ahead and ring him up and.
Yeah, he wasn't at his house, so that might be it.
Gordon, call the matter of Yelm versus Ryan Fleming. Mr. Fleming, you're muted. If you'd unmute yourself, we'll address your matter at this time. Good morning to you.
Good morning.
Your Honor, this is Andrew Fleming. He's number 3 and 4 off the 11 o'clock calendar, Your Honor.
Mr. Fleming, sorry.
It's okay.
We're going to take your matter now. I'll turn to your attorney for the status of the matter.
Thank you.
Thank you.
Today, we have an agreed resolution to this matter. The driving the license suspended 2nd degree case is going to be amended to driving the license suspended 3rd degree, $150 bench probation fee. Mr. Fleming is going to be executing a plea to the DWS 3, and then is going to be asking to mitigate the improper lane usage ticket. Thank you.
That's all correct, Your Honor.
Mr. Fleming, disagree with anything at all Mr. Sneva just said?
No, sir, I do not.
For the record, your name is Andrew Allen Fleming.
That's correct.
I looked at a statement of defendant on plea of guilty to an amended charge of driving license suspended or revoked in the 3rd degree. That charge is a simple misdemeanor. The maximum penalty on conviction to be 90 days in jail and or $1,000 fine. Plea form tells me you're 54 years of age and you have a GED.
That's correct, sir.
Any issues reading, understanding the English language?
Not really, no.
Gone over the plea form with your attorney?
Yes, sir.
If you had any questions, were they answered?
Yes and yes.
And if I accept the plea, you give up the rights contained in paragraph 5, there's no trial, no appeal, simply a sentencing which could be up to the maximum regardless of what's recommended. You realize it.
That's correct, sir.
With that in mind, as to one count of driving a license suspended, revoked in the 3rd degree within the city of Yelm on December 3rd, 2021, how do you plead, guilty or not guilty?
Guilty.
Make that plea of your own free will.
Yes, I have.
Anybody make any threats or promises to you to make you plead?
No, sir.
And the plea to be freely, knowingly, and voluntarily made.
Yes, sir.
Your license was suspended by the Department of Licensing when you were cited on December 3rd.
Yes, sir.
We'll find the plea to be freely, knowingly, and voluntarily made. Mr. Fleming, anything you'd like to tell me?
No, I was just driving for the work truck that I was, for the job I had. Ed's moving to storage.
Do you know what you need to do to reinstate your license if you haven't done that already?
Pardon me, sir, I didn't hear you.
Do you know how to reinstate your license?
Yes, I believe I do now.
I'm going to wish you the best of luck. We live in a world where you've got to be able to drive to function at all. So I'm going to impose a recommended sentence of 90 days in jail, suspended for a period of a year on the condition you have law-abiding behavior and pay a cost in the amount of $150. We'll say
Thank you, Your Honor.
25 a month. I'd rather you devote your money to keeping your license current. So good luck with that, and you take care. All right.
All right. Thank you, sir.
And the infraction, let's mitigate that to $100 even, and then we'll just add that on to the other assessment.
Okay. Thank you, sir.
Mr. Fleming, good luck to you. You take care.
Thank you.
Thank you for your appearance and your patience. We'll be sending you a copy of today's documents.
Okay. Thank you, sir.
Thank you.
Yep. You have a good day.
You as well.
I have 2 matters left. We're almost 10 after here. I'm just gonna deal with those if the court's willing to. I haven't heard from either person.
Sure, you bet.
The number 8, Lokalani Viegas, 18 years old, have not heard yet from this person. I'm asking we could reset this. I guess it would be to a good cause or show cause hearing. And I'm asking for this one that we reset anyway without a warrant, just given this is literally alleged to have occurred on their 18th birthday, or we'd be in juvenile court. So asking to give them one more shot to appear.
And I think maybe your mother is scheduled to appear today anyway.
So we may see her. I did not realize that.
And I'm guessing she may show up with her mother like she did last time. But in any event, I'm going to note the non-appearance for speedy trial purposes. Grant any objection at all to and reset the matter out a month as to given her age and lack of any significant record. Reviewing the JNS on Andrew Fleming. Grant, how about a signature on Fleming? Maybe that's
Do I need one as well on that?
Yep.
Okay, sorry. That might be me then. Sorry.
And if I hit the refresh button, that helps.
my last matter, sorry, you ready? Okay, sorry. I swear they need like a stoplight system or something, so I can tell.
We ought to,
when people
because
are-
I'm not slow, I'm not fast.
No, I just like no one knows where everyone's at. Every court that has courts is like this. We never know where each other's at.
Yeah, there's no
There's no way to know.
unanimity of perception here.
Right. The last matter I have, Your Honor, is Rand Wells. Looks like there's 3 matters. I have no information to provide the court in this matter. Have no contact yet.
Oh, boy. Any idea at all?
I looked at the reports and I'll just leave it at that.
That's been in and out of warrant status.
We were just talking about that.
And it's
$500 cash for one.
on each or?
Yeah.
Okay, so ordered.
Thank you.
And the city may be,
Are we off the record?
the city may be amenable to bail forfeiture. But this is bounced in and out of.
Right. Well, hopefully we can address it when I get in touch with. Thank you.
Hey, Josh, you take care. You have a good day and stay safe, stay well, stay well.
We could take up number 9 on the 10 o'clock. It's Ivani Rose Marie Villegas.
Okay.
Hello.
Ms. Villegas, how are you?
Hi. I'm pretty good. How are you?
I'll refer to him for the status of your matter. Good morning to you.
So good morning. This is
Morning.
Dan Haverco on the record here. Good morning, Ms. Villegas. For the court's information, the parties have reached an agreement, that being a stipulated order of continuance. I prepared the document. I've gone over with Ms. Villegas telephonically what's in the form and what the conditions are. We're proposing the matter be set over for 12 months on the condition that she not have any criminal law violations and pay $250 court fee.
And that's with regard to all 3 charges?
Yeah, it is.
And the charge will be dismissed?
Yeah, right.
Ms. Villegas, I'm looking at a stipulated order of continuance. Have you gone over that document with your attorney?
Yeah, we went over that a couple of days ago.
And if you had any questions about what it meant to enter into an agreement like this, was your question answered?
The only question was I kind of forgot the amount that I was supposed to be paying afterwards, and it was $250, correct?
Could you repeat that?
I kind of forgot the amount I was supposed to be paying after, and it was $250, he said.
Yes, $250.
Okay. Okay.
That's the least important.
That would be my only question.
We're setting you up on a payment program in the agreement at 25 a month. That becomes a problem, let us know. But in any event, this is if you abide by this agreement, the charges, I should say, will be dismissed. If you violate the agreement, we're simply going to have a hearing based on the police reports, and that would result in the possibility of jail time and criminal convictions on your record, which is something you definitely do not want. Now,
yeah,
that's what happens because you've given up your right to go to trial, have witnesses and appeal if for some reason you should have an adverse result at trial. Now, I remember the case well. This is a case that could have gone south in a real hurry with people injured. And I'll stop right there. I want you to take care of yourself. There's not any recommendation here for any treatment or evaluations. Simply stay out of trouble. If you think there's
Alrighty.
an issue that you need to deal with in your own life, we're going to leave that up to you and your family. But I'm going to wish you the best of luck. You take care of yourself, and if all goes well, we'll be just simply dismissing these charges 12 months down the road, okay?
Alrighty.
So I guess good luck to you and take care. If you have any questions.
Alrighty. I want to thank you guys so much for everything, and I want to thank my lawyer and everyone.
We're going to wish you the best of luck, and we will also be sending you a copy of the agreement. Now, look it over carefully, and if you have any questions, be in touch with your lawyer, okay?
Alrighty.
You take care. Have a excellent rest of the day.
Alrighty, and I'll get a hold of my sister and my mother. They will be on their way soon. Hopefully.
We'll deal with that when they get here.
Alrighty.
Take care.
It's too. Okay. So anyway, Mr. Damian indicated he was having some difficulty calling in. And so.
Who is this now? I was.
I'm sorry, Judge. I was just letting you know. Yeah, I was just letting you know on the 11 o'clock, Mr. Damian called. And I told him because if he can't figure out how to call in, he's at Fort Lewis, and just to drive in. So he said he's driving. Okay. It's just something quick. So we're ready. What's that? He said he's on his way. I mean, it's probably not more than a half hour.
What's that?
From Fort Lewis to here?
Yeah.
Already. He's gonna sign off levying the infraction deal or something. That is. If I don't have to sign it, I won't.
Yeah, because I represented Yvonne. Yeah. So I think he was assigned to work on.
Doing better. If I don't need you, doing better. In that case. Take the matter of Yelm versus Ms. Schlimme. Ms. Schlimme, you're present, but you're muted. You're going to have to unmute yourself, and if you would do that, we're going to speak with your matter.
Good morning.
Thank you. Good morning. Your attorney's in the courtroom. Matter is set for a compliance hearing with regard to the diversion that was entered. I'll turn to Mr. Haverko for the status of the matter.
Thank you, Your Honor. So I've had an opportunity to discuss the matter with Ms. Schlimme. We would admit the violation that she's so far failed to show proof of either assessment or, alcohol drug information school, if that were the result of the assessment, and she's failed to show yet proof of the victim impact panel. She's, at or beyond the continuance period, apparently.
I think she has the May, according to what I have, the SOC would be at May 13th.
So I guess if that is the case, let me just, because I'm assuming, I just wanted to check the docket here and see when did we actually do that. So, okay, so, I mean, I know we're on here for the city's motion to revoke. I guess, I don't know what Ms. Schlimme could get done, but let's see, we're here in, February, and so I guess my argument would be, I know if we were at the very end of the period, the city's position would be, right, that they wouldn't be agreeing to extend the period, and they would be wanting to complete their motion to revoke. I guess my argument is a technical argument, which is we do have a little bit more time in the period.
But isn't the agreement that she was going to get that done within, these things done within so many days of entering the SOC?
Yeah, you're right. I think it does say alcohol assessment within 120
Yes.
days. Yeah.
Alcohol drug assessment and then compliance with any recommended treatment, and nothing was really.
I didn't know that.
Right. And so I don't know if there's any way to prevail on the city to not you know, because I inquired whether the city was willing maybe to extend the period, but I understand the city's position. They said they don't want to extend the agreement period. But again, it's up to the city, but would the city consider just?
Your Honor, it's just been the city's experience that if people don't take this seriously immediately after having this opportunity, that they're not going to. City's just asking that we revoke the agreement be revoked, and the minimum, mandatory minimums be applied.
And I know Your Honor's position is, you know, it's really between the parties, and I understand that. She just probably would want the court to know it's just been a real difficult struggle for her during the last year with employment. She hasn't had health insurance, and so apparently she talked to one agency about an assessment. They wanted 400 some odd dollars, and she's just been in a very difficult position. She's apparently she's in another state right now, going to be traveling apparently to I think the East Coast, pursuant to some employment opportunities. The difficult situation she's in now is that even if the city weren't moving to revoke, she's not in Washington, so you have the issue of whether it's a state of Washington certified alcohol treatment provider. So she's just unfortunately kind of running into a situation where, you know, she has sort of run out of time. But again, she just wanted everybody to know the struggle she's had in the last year with respect to just, I guess, just some real struggles with respect to employment, money, and it's just been a very challenging, you know, time for her. Just she, you know, that she just want the court to know that. But, you know, I don't have, you know, as the defense, I don't have a legal argument, you know, to oppose, you know, the city's motion. But, you know, so.
That was really awesome.
Ms. Fleming, is having heard from your attorney and the city, once again, this is a contract between yourself and the city. I do find this is a material breach of that of the kind of. We don't have anything on file here that's been a considerable period of time, well beyond the time allowed for this to happen. I'm gonna, based on the police reports, I'm gonna enter a finding of guilty to one count of physical control. I'm going to impose 364 days in jail, give you credit for 1 day served, suspend 363 on the condition you have law-abiding behavior. There's a mandatory fine in the amount of $940.50, which I'll impose. I think I'm just going to stop there with the imposition of the fine. We'll be sending you a time payment agreement. Condition of the suspended jail time is law-abiding behavior, no criminal traffic offenses, and that especially comes to the consumption of controlled substance, alcohol, and driving. We will send you a copy of the judgment and sentence, Ms. Fleming. I'm going to wish you the best of luck and just hope the best for you. That's all I could do.
I do appreciate that, Your Honor.
Just let me take care of yourself.
Thank you.
the form doesn't really lend itself to. But I would just put it under other. $364 pulls $363 incredible what these are. Yeah. So we'll be sending you a copy of today's order, but that concludes the hearing. You can sign off now, and then again, take care of yourself.
Thank you. You have a great day, Your Honor.
Thank you. Reschedule. Yeah, I have to check the fine box and certain. Yeah, that's the trouble with this thing. It doesn't. Well, the good news is you're here. The bad news is you're late and your attorney's left. Not having heard from you. Motion to issue a warrant was made, but I think we'll quash the warrant and reset it to next time. And please, yeah, be in touch with your attorney and.
Nobody's contacted me
from Ms. Villegas. But your attorney is Mr. Sneed, and that would have been on the recent, the contact information and his telephone number would have been on the last order you got.
Okay, and is hers the same?
Yeah, same. Josh Stevens. So hang on. What we'll do is generate a order reset that'll have your attorney's name on it. And what we'll want, that'll take a minute to generate, but I want you to call him today. And, he hadn't heard, and I don't know if he has any contact information for you. The way we set it up, it's pretty much up to you. We let him know that, but we don't throw your information around. We let him know that he's been appointed to represent you and then give you his phone number. So that's the way it should go. That's the way it should go first. But give us a minute here. This stuff all has to be done electronically. Yes.
Someone can resolve this dog issue right now without having to go back.
That's once an attorney's involved, that sort of throws it into a whole new ball game. If there was a way to do that, fine, but reset it to March 3rd. It's another month, more time goes by, but hey, a reset's better than a warrant.
Yeah. I thought it was next week sometime.
Oh, boy.
Yeah, I just got my sister at my house with her grandkids, so last night was pretty good.
Yeah, sometimes it's a little hard to. I'm electronically signing the order, resetting. This always takes a little longer than you think it's going to. Ms. Villegas, you're reset to the same date, March 3rd. I'm signing the order as we speak. Now you can get a copy of this by going to the window up the courtroom and to the left, and Mr. Stevens' address and telephone numbers is in the order. Go ahead and highlight that and give Josh a call.
Okay, I will. All right, thank you.
Take care.
So when the court's ready, number 2 on the 11 o'clock, this is Mr. James Damian.
Your Honor, city has a motion.
And city has a motion.
City moves to amend the charge to negligent driving second degree.
Second degree or?
Second. Yes.
Second. Well, that's an infraction, so. Mr. Dunn, I'm looking.
Okay.
I'm looking at an SOC, but this is going to be an outright admission and. Yeah. Okay. So Damian, this is kind of your lucky day. An amendment from any sort of criminal charge to a civil infraction is always about the best news that there could be. Negligent driving in the second degree is a simple infraction. You don't plead guilty or not guilty to it. You admit it or deny it. If you admit it, I'm going to impose a fine. No possibility of any jail time, and that's going to conclude the matter. And the criminal charge will be dismissed. You admit that you committed the offense of negligent driving second degree on November 23rd, 2021.
Yes, sir.
Well, recommended fine.
Your discretion, Your Honor.
It's written up as
What's the default? What's the bail on it?
that's $250. It's one of those $553 shots.
Right.
Let's reduce that to $250.
Yeah.
Let's go $250. Why don't we do that by the month? $50 a month.
You said 250? It's 250 total. You need to pay it today or make payments of 50 a month? I'll pay it up front. Okay, he'll pay it today.
So we'll do that. Mr. Damian, try and think, how would you feel if
Your Honor, he hit a curb. He hit a curb.
Yeah, he hit a curb.
oh dear.
Yeah, curb in a ditch. So it's like,
How's the curb?
basically, the car hit the curb and the car lost.
Yeah.
Essentially.
That's always
It's like here.
sorry, that's not be familiar with the facts. I assume things that I shouldn't assume.
Yeah.
But Mr. Damian, I'm going to wish you the best of luck. You take care of yourself, and that takes care of this, I'm sure, in a minute.
So hopefully that will keep you out of trouble in the end, because it's a non-criminal offense, like a speeding ticket. Yeah. So I'm assuming and that's it. Yeah, just go to the window and.
Mr. Damian, you can go to the window, get a copy of today's order. That'll have the information on that. If there is any sort of issue comes up with making the fine payments, let us know. That's something very easily dealt with.
You guys take a debit card for the payments? You guys take debit card or cash for that?
I don't know. They don't trust me with money, so that's.
Thank you, guys.
See you.
Mr. Damian, good luck to you. You take care. Oh. Yeah, yes. That was moved to.
We dismiss that case.
Mr. Palmisano, you're muted. If you'd unmute yourself, I'll address your case at this time.
No, I just have no shows.
Mr. Palmisano, if you'd unmute yourself, that'd be great.
You just have the no shows?
Yeah. Hey, good morning, Mr. Palmisano.
Morning.
Well, it's the good news is the city has moved to dismiss your case, and I granted that motion. Do you have any objection to your case being dismissed?
No, sir, I do not. Thank you very much.
Would not think so. You take
I'm
care.
on
And, dismissal's already been entered. You have a good day. Thanks for signing in, and that concludes the hearing.
Yes, sir. Thank you very much. You have a wonderful day.
You as well. Well, that is that. You guys want to do the no shows?
Yeah. I haven't had any contact with Christopher Bell Pier.
Pier.
Yeah. Yeah, let's see.
Looks like Dale is supposed to box check. City moved to forfeit.
Yep, forfeit, $5,000 cash or bond.
They'll post it. We'll send the appropriate letter to the bonding company and issue a warrant, 5,000 cash or bond.
And from Mr. Aaron Thode, I haven't had any contact.
That's third degree, $5,000 cash or bond. The Boxton checks.
Aaron James, though, I think it probably. Aaron.
Here at his last experience was in January 6th. He was FTA. Looks like he had requested a reset. He had notified that day. So we just said it. Before that, he had been before that was warrant status.
Having been in warrant status, I'm inclined to reissue.
Yes, please.
Sword, 5,000 cash or bond. That's 10 o'clock. Mr. Hemico, that I think. brings
And then
us
the
to
other, well, yeah, the other one is on the 11.
Chris Jackson.
Yeah, Christopher Jackson. Have been unable to successfully contact Mr. Jackson.
Box was checked. That's indicated on the docket. Jackson, 2 cases, Fifth Third and Crim Trust 1, October 18th.
5,000 each.
Each,
Please.
so ordered. And I think that's it.
Yeah.
Now on record, I'm going to call the 1 o'clock arraignment calendar. I see we have one attorney matter present. I'll call that matter first. That'd be Lydia Lopez. Ms. Lopez, if you come up to the council table with your attorney. Good afternoon. Is your full name Lydia Consuelo Lopez?
Yes.
Ms. Lopez, the citation I have alleged on or about January 22nd, 2022. You committed the gross misdemeanors of DUI and reckless endangerment. Maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. You were also cited for resisting arrest. That's a simple misdemeanor. Maximum penalty on conviction would be 90 days in jail and or $1,000 fine. At this point, I'll turn to your attorney for the entry of a plea on your behalf.
Thank you, Your Honor. Phillips on behalf of Lopez, on behalf of Ms. Lopez, we're asking the court to accept the plea of not guilty.
Stipulation of probable cause
Yes,
for
please.
purposes of this hearing only, of course.
Yes, please, Your Honor.
Ms. Lopez, a plea of not guilty has been entered on your behalf. That preserves your rights. We set the matter for a pretrial. So we have March 3rd, 17th, or 31st, and private attorneys are usually done at 9 o'clock. What works best for you?
Your Honor, if we have the Your Honor, it's 3rd or the 31st.
Either one,
Okay.
let it be your choice.
Okay. Very quickly, please. Your Honor, if we may just please have a moment. Yes, Madam. Your Honor, would since it's pre-trial, would we be doing this via virtual, Zoom, or in person?
Leave that up to you.
Okay.
Leave that up to you. That would be your choice. On the today's order, setting a pretrial, the Zoom information will be there.
Yes, sir. Okay. Your Honor, may we please have March 31st?
March 31st it is, 9 o'clock in the morning.
Thank you, Your Honor.
So Lopez, there's some pretty standard conditions of release given the nature of the charge. Always show up for court when scheduled. No criminal law violations, especially no violations involving alcohol. Don't drive unless you're licensed and insured, and no drinking and driving at all. And if any officer, for any reason, has an opportunity to ask you to take a breathalyzer, you're to do so. Mr. Dilly, does the city request any additional conditions? Not hearing, that's, I guess that the answer is no.
Thank you.
Ms. Lopez, any questions at all?
No.
This takes me a minute. I will be signing a order on today's hearing when I'm given the chance. So you and your attorney, this takes me a minute. You and your attorney will be able to get a copy of today's order by going to the window that's out of the courtroom and then to your immediate left.
Your Honor, I will, or I can just email it to Ms. Lopez.
Perfect.
Thank you so much.
You take care. Thank you for your patience. Thank you for appearing, and we'll see you in March.
Thank you, Your Honor. It's good to see you.
Take care. The rest of you here, before I call you up one at a time, I need to advise you of your rights. You have a right to have a lawyer represent you at all stages of any criminal proceeding, including today's hearing, which is an arraignment. Typically, a plea of not guilty is entered today. That is not any great statement about the case. It's simply a way of preserving your rights until you can attend a pretrial conference. Purpose of a pretrial conference is to do you have any questions at all about your rights? Any question about the charges? Say either ask myself or Mr. Haverco, our public defender, who's here to help you with this hearing. I will appoint him to represent you for today's hearing by entering a plea on your behalf and speaking on your behalf. And he will determine later whether you're eligible for an attorney at public expense for the duration of your case. Is Miranda Eschenbrenner in the courtroom? Miranda Eschenbrenner does not answer. A number of people won't answer at the end of the today's hearing. I'll go back through the files, and if there isn't any reason for somebody not appearing, a warrant will issue for their arrest. And so you've saved yourself a warrant by just simply appearing today, and I thank you for that. How about Joel Baker? Mr. Baker, come on up and have a seat at the council table. Is your name Joel Richard Baker?
Yes, sir.
Mr. Baker, the citation I have alleges that on the 27th of January 2020, you committed the offenses of theft in the 3rd degree, 2 counts. Those charges are gross misdemeanors. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. Mr. Haverko, I'll appoint you to represent Mr. Baker for purposes of this hearing and enter a plea on his behalf.
Thank you, Your Honor. Would stipulate to probable cause, ask the court to enter not guilty pleas to both counts.
Mr. Baker, we're going
Got
to.
your phone number right
Any question about what Mr. Haverko just said?
No.
We set the matter for a pretrial hearing. Conditions of release, of course, are law-abiding behavior, appear for court as directed, and stay in touch with Mr. Haverko, your attorney. Your pretrial will be on March 3rd at 11 o'clock in the morning. I'll sign a order to that effect, and you get a copy of that by going to the window outside the courtroom and to your left. And reviewing the day's order as we speak.
Sign with this thing on this pad. That's correct? So, what's your new number? It's okay. That's okay. 4,000. Okay. Okay, great.
Mr. Baker, that concludes the hearing. They've signed the order. And again, get a copy of that before you leave. And please stay in touch with Mr. Haverko. Case has got some age on it, but hey, we're dealing with it now. So look forward to seeing you in March. Take care.
Thank you so much.
Stacy Castaneda. Go ahead and have a seat if you would. Is your full name Stacy Ruby Castaneda? The citation, once again, and this is a companion case to the one we immediately previously heard. It's alleged that on January 27th, 2020, you committed 2 counts of theft in the 3rd degree. Again, gross misdemeanor, the maximum penalty and conviction to be 364 days in jail and or a $5,000 fine. I'll have Mr. Haverko enter a plea on your behalf.
Thank you, Your Honor. Would stipulate to probable cause, ask the court to enter not guilty pleas on both counts.
Plea of not guilty has been entered on your behalf, ma'am. We're going to set the matter for pretrial probably on the same date as before. I'm going to ask that you have no contact and do not discuss the case with Mr. Baker. It's entirely possible that given the proximity of your cases to each other, that there may be a conflict. Probably not, but that could happen. We'll address that issue if it arises. Your hearing will be March 3rd, 11 in the morning. And again, conditions release, law-abiding behavior. Stay in touch with Mr. Haverko. Now, having signed the order, you're able to get a copy of that at the front desk. Robert Forgey, Forgey. Good afternoon, sir. Is your full name Robert Michael Forgey?
Yes.
Thank you for appearing. Citation alleges that on or about June 22nd of 2021, he committed the offense of theft in the 3rd degree. Once again, that's a gross misdemeanor. The maximum penalty is 364 days incarceration and or a $5,000 fine. I'll ask Mr. Haverco if he would to enter a plea on your behalf.
Thank you, Your Honor. I stipulate to probable cause, ask the court to enter a not guilty plea.
We have not guilty has been entered on your behalf, Mr. Forgey.
Phone number. Sign.
It will be March 3rd, 10 a.m. Conditions release, show up for court when directed, and no criminal law violations. And of course, stay in touch with your attorney. And no signing the well as soon as Mr. Haverco has. Maybe we're gonna hold up for a minute and
Yeah, Your Honor, can you hear me?
loud and clear, loud and
Perfect. Okay.
It's one of those days.
Indeed.
Mr. Forgey, I want to thank you very much. And again, you can get a copy of today's order, which I just signed at the desk out the courtroom and to your immediate left, if you would. Timothy Fries. Mr. Freeze, if there's a way to mispronounce a name, that's exactly what I'm going to do. The city may have a motion in your case.
Yeah, city will move to amend to no vol 2nd degree and mitigate the infraction.
Mr. Freeze, what just happened is this, as you walked in here, you were charged with a criminal offense that bears up to 90 days in jail. The city has amended the charge from a criminal offense to a civil infraction. All that means the worst thing that can happen to you is a fine. You don't plead guilty to an infraction, you admit it or deny it. If you admit that on January 22nd, you had bad headlamps on a vehicle and didn't have a valid license with you, I'm going to impose a fine and that will conclude the matter. Do you admit or deny?
I have my license.
Perfect. That I like to hear. But how about on January 22nd?
My headlights are, my headlights work. My headlights are fixed.
I'll assess 150 on no valid operator's license and and 100 on the others for a total of 250. You can pay that at $50 a month. You have your license now. That's the best news you could have. Keep it in effect, and you can pay that at the. We'll have you sign a time payment agreement. You can pay it over time, or if you want to take care of it all today, that'd be the thing to do. You have your license back. It's a lot harder to get it back than it is to lose it, but now that you have it, keep it, okay?
Yes, sir.
Any questions at all?
No.
Good luck. I'm signing today's order. You'll be able to take care of the situation at the front desk. Sarah George in the courtroom. Sarah George. Good afternoon, ma'am. Is your full name Sarah Elizabeth George? Ms. George, the citation I have alleges that on or about January 18th, 2022, you committed the offense of assault in the 4th degree domestic violence. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I would ask Mr. Haverco, enter a plea on your behalf at this time.
Thank you, Your Honor. Stipulate to probable cause, ask the court to enter a not guilty plea.
Ms. George, your rights are preserved by the entry of that plea. We're going to set the matter for pretrial, and a condition of release is no contact with Justin Kelly while the matter is pending. Does that pose any problem at all?
Yeah, no.
Okay, thank you.
Sign right here.
City request any further conditions? Your pretrial is going to be March 3rd at 11 o'clock in the morning. Other conditions are, of course, law-abiding behavior, and stay in touch with Mr. Haverco while the matter's pending. Ms. George, that concludes the hearing. You can get a copy of the order out the courtroom window and to the window at your left.
Thank you.
Take care and thank you. John Kirkus in the courtroom. John Kirkus. Good afternoon, sir. Is your full name John Kenneth Kirkus?
Yes, sir.
Citation that I have alleges that on or about December 29th, 2021, you committed the offense of hit and run unattended. Now that charge is what they call a simple misdemeanor. Maximum penalty on conviction to be 90 days in jail and or a $1,000 fine. I'll have Mr. Haverco enter a plea on your behalf. And once again, if you're indigent, he'll represent you through the course of the case.
Thank you, Your Honor. Thank you, Your Honor. Would stipulate to probable cause, ask the court to enter a not guilty plea.
Kirkus, plea of not guilty has been entered. Again, that preserves your rights.
Write your phone number down. Right in here.
So that not guilty, that make me go to trial now?
No. Well, it just starts the case, so we can have a discussion later.
Can I take care of it today though?
No, you really can't. Which is not a good idea. Anybody wouldn't want to do that. Go ahead, sorry. Just put your name, your phone number in there. Yeah. We'll sign your name on this electronic pad.
Pretrial will be March 3rd, 11 in the morning. Law-abiding behavior. Don't drive unless licensed and insured, of course, and stay in touch with Mr. Haverco while the case is pending.
You said March 3rd?
March 3rd, yes, at 11 o'clock, and that will be on the order that you'll get a copy of.
Yeah. So it's 229 726 215.
There's no way to take care of this today.
No, Judge, just so you know, defendant wants to know if he can take care of this today, and I said, not really. We don't do guilty pleas and things like that, arraignments, generally not a good idea.
Yeah, I just got a lot of training coming up with the Army, so.
Well, we could always, when are you going into training?
I have to go get the dates because it's usually like 2 weeks out when I find out.
Well, I'll tell you what.
Mr. Kirkus,
He's in the Army. He's going to be doing some training. If we could take care of it 2 weeks from today, would that be soon enough?
Yeah, usually I get notified pretty much like 2 weeks out from when the training event's coming up. So it's like not usually set in stone, sir.
I mean, I don't have a problem, if we just set it 2 weeks from today and just set a quick pretrial. Sure.
What?
You'll get the paper. It'll be 2 weeks from today. You'll get the paper. Right.
I'll see what the date was.
Oh, you want to check?
Yeah, because I have training.
Check your training. Check your schedule.
So, yeah, the 17th I get that. So from the 11th to the 17th.
Is that okay? Is the 17th okay?
That's the day I get back, so it'd be like the 18th or after.
Oh, so if we could set it then March, let's see, so the next court date is, so is the next court date after the 17th, is
the
that?
31st, March 31st.
No, I was thinking after February 17th is the next court date.
March 3rd.
Well, it'd be March 3rd. It was set March 3rd, if that's okay.
I think March 3rd. February 17th is
No, apparently he's just getting back on the 17th, so it's got to be after, he's going to be doing some training here shortly. So that
March
gets,
3rd is.
yeah.
It's gonna be good. Okay, we'll leave it at that.
Yep.
And Mr. Kirkus, if there's ever any problem with training, something gets scheduled, something jumps up, as long as you're in touch with your attorney and we know we don't lose track of you, as long as we know what's going on, there isn't going to be any problem. We reschedule stuff all the time. The important thing is contact. Let us know.
Yes, sir.
And you'll sign it and have signed the today's order. You can get a copy of that again at the window. Good luck to you and thank you. Is John Lewis in the courtroom? John Lewis. Mr. Lewis, come on up and have a seat next to Mr. Haverco. And this might be one of those cases where the city could have a motion. Mr. Adele, you're muted. Well,
He sent me a text earlier asking if we could hear him.
no, you're muted. It looks like you're muted on the, now you're.
There we go.
There we are. We're fine. Perfect.
Perfect. Yeah, city moves to amend to no vol second degree, recommend a $250 fine. I'm sorry, $150 fine.
Lewis, that.
I take the deal.
Okay, that means, well, you now have 4 infractions, no valid operator's license, looks like no insurance, no registration or plate, and expired registration. What I would do is with the insurance, that's a $553 fine. If you admit that, I'm going to reduce that to $150 or something and just make it part. You admit the 4 infractions?
Yeah.
150 on no valid operator's license, second degree, 150 on no insurance, and then 100 each on the other 2 infractions. That adds up to quite a little bit, but a lot less than what would have been. Do you know what you need to do to get your license?
You know, you said it a long time ago, it's like, I'm gonna catch 69. In Nevada, I had 6 tickets in Nevada. Yes,
boy.
when I came here, and I rode across the city, they squashed 4 of the 6, but they won't squash 2, which will stop me from getting my license here. And I don't have the luxury of going back there.
Being able to, yeah.
I don't have it. Otherwise, yeah, I might, you know, and I have to survive, you know, I have to, you know, my house is no close to walking distance, anything.
Sorry to hear that. I don't know what you can do, but that is a problem when the problems are in another state and you have to go there in person.
But I appreciate you, Judge. I appreciate it.
But at least it's no longer a criminal offense with us. It might be in some other jurisdiction, but yeah, until you can get relicensed, I wouldn't be driving. But good luck to you. You take care of yourself, and again, you can get a copy of today's order by going to the window outside the courtroom and to your left.
Thank you. I'm all that big chips. Thank you.
Good luck to you. You take care, and Thanks for your patience.
Thank you.
Corbin Nelson. Mr. Nelson, if you would come up and have a seat at the council table. And this is, again, Mr. Nelson, one of those cases where the city may have a motion, but there you go.
Thank you, Your Honor. Yeah, city moves to amend to no vol second degree and recommend $150 fine and mitigation of the insurance and the plate infraction.
Got it. Mr. Nelson, did you follow that? It's now infractions and not a criminal offense.
I did follow
And if you admit, you don't plead, again, there's no possibility of any jail time with an infraction. But if you admit the infractions, I'll impose the only thing I can do, which is a fine. And you know what I'm going to do there. And that takes care of the matter. Any questions?
No questions today. I wouldn't have anything else to request either.
That's it. I'll take that as an admission. Assess 150 on the Noval 2, and then 150 on the insurance, and then 100 on the registration of plate infraction. You know what you need to do to get your license reinstated?
Going to online.
I'd make that a priority. I'd make that a priority. So Nelson, I'm now signing the today's order. If you would, please pick up a copy at the window out the courtroom and to your left. And if you have any problems making the fine payments, let us know. Let us know. That's something we can easily do something about. But what I'd like you to do is do what you need to do to reinstate your license. Good luck to you.
Thank you very much.
Take care. Antonio Ray does not answer. Oh, yes. Cyrus Rosnick. Good afternoon, sir. Is your name Cyrus James Rosnick? Mr. Rosnick, the citation I'm looking at alleges that on or about January 24th of 2022, you committed the offenses of vehicle prowling second degree, theft third, and obstructing a law enforcement officer in the performance of his duty. So gross misdemeanors, the maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. What I'm going to ask Mr. Haverco to do is enter a plea to those charges on your behalf.
Thank you, Your Honor. Would stipulate to probable cause, ask the court to enter not guilty pleas on counts 1, 2, and 3.
Mr. Rosnick, any question about the charges? We're going to set the matter for pretrial conditions of release. You know what they're going to be. Appear for court when directed, and no criminal law violations. Okay. Pretrial is going to be March 3rd, 2022 at 10 a.m. Expect you to maintain contact with your attorney between now and March 3rd. Okay.
So sign your name with this pen on this pad.
Mr. Rosen, that concludes today's hearing. Please pick up a copy of today's order at the window outside the courtroom to your immediate left.
Yeah.
James Wilcox. Good afternoon, sir. Is your name James Arthur Wilcox? Mr. Wilcox, the citation alleges that on or about October 10th, 2021, you committed the offense of violating the terms and conditions of a no contact order. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I will have Mr. Haverco enter a plea on your behalf to that charge.
Thank you, Your Honor. Stipulate probable cause, ask the court to enter a not guilty plea.
Mr. Wilcox, a plea of not guilty has been entered on your behalf. We're going to set a pretrial for March 3rd, 11 a.m. Now, the condition of release is law-abiding behavior. That would include do not violate any existing no contact orders. Any questions?
So I'm a transient as of October 3rd of 2021. I had no clue about about the October 25th hearing.
For what? Here?
From the last, that's why I missed the, so I don't have an address, Your Honor.
Well, if you don't have it, we're going to give you a copy of today's order, and you can come here and have court right here. And it's
sign your name right here. With this pen. What's your number?
Mr. Wilcox, I want you to understand the violation of a no contact order, especially more than one, that can wind up being a pretty serious time. Now that's a condition here of you being not held in custody, is that you abide by any no contact order.
What's that? Oh, you're charged with the no contact order protection order violation. So what will happen is, well, I don't know. I have no idea. So what will happen now that I'm appointed, I will wind up being sent a copy of the police report. When I get that, then I will reach out to you and talk about it with the other incidents. And then we'll talk about kind of what to do. Yeah.
Mr. Wilcox, any other questions? No, make sure you stop at the window and get a copy of today's order so you're reminded of the court date. Hey, take care of yourself. Titus Williams. Mr. Williams, thank you for your patience, okay? And good afternoon.
Good afternoon.
Full name Titus Keithville Williams.
Yes.
Mr. Williams, the citation I have alleges that on or about January 20th, 2022, you committed the offense of hit and run attended vehicle. That is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I will appoint Mr. Haverco to enter a plea on your behalf and represent you through the course of your case if you're indigent and qualify. Mr. Haverco.
Thank you, Judge. Would stipulate to probable cause, ask the court to enter a not guilty plea?
Once again, Mr. Williams, that preserves your rights until we can have a pretrial conference. In the meantime, law-abiding behavior, don't drive unless you're licensed and insured, and stay in touch with your attorney, okay? Any questions at all?
Will this prevent me from getting my license?
I'm not sure I understand. the
Oh,
question.
he was asking, Your Honor, he was
His
asking the
license.
court, will this prevent him from getting?
No, this is simply a pending charge. The fact that you've been cited with something doesn't have any effect on your license, and this charge doesn't affect your licensability.
Okay.
March 3rd, 10 a.m. is the date of your next court appearance.
Excellent.
Mr. Williams, that concludes today's hearing. We'll see you on March 3rd. Scheduled time is 10 o'clock. And again, stay in touch with Mr. Havercook, okay?
Yeah. I'll just go
You
ahead and
take care.
step-
Have a good day.
Stop at the window and get a copy.
And with that, I think we're going to go off record.
All right.
That's a pretty good appearance to the rate today.
Yeah.
Yeah, no, not too shabby.
Yeah, that's it.
Yeah, for such a short.
All right, everybody. We'll see you in a couple weeks.
Brent, take care. See you, I guess, next month.
Yeah. See you.
array, there's already Back on record for the no-show on the 1 o'clock random calendar, Eschenbrunner, Miranda. I do find probable cause for the issuance to her of a theft third citation. Warrant will issue 2,500 cash or bond. The other individual on the calendar, Antonio Ray, I think wanted to be heard on this warrant. The warrant will stay in effect. That brings us to the 2:30 infraction calendar. It's now 2:43. That's with no appearance. If Rosa Alejandra Ortega shows up by the end of the day, simply reset her for the next day. And if she doesn't show up by the end of the day, FTA. Go off record for the duration of the day.